Hey everyone, Harry here to talk about the shadow docket express rolls on, and even in a more extreme way. So we've been playing out over the last, well, really months, but in particular weeks, the issue of whether Trump can fire a commissioner of the FTC, the Federal Trade Commission, and that would have been something clearly improper as of only a year ago, because there is a foursquare precedent from 1935. You've been hearing about this, the Humphreys executor case, in which the court specifically said the Congress can prevent the president from doing exactly that. Now, that has come, that Humphreys executor case, to be increasingly outlying. It is, in a sense, a limitation on the president's full-bodied power to fire anybody for any reason under the so-called rubric of independent agencies. Indeed, it has come to be the very notion of, do independent agencies exist? And this is a somewhat arcane but really important battle that's been going on within the Supreme Court, as over the last especially 10 years and the Roberts Court, you have found a series of decisions saying, yes, we know that Congress passed this law, and in this law it said that the president can't just do it willy-nilly, but we're finding that that's a violation of the separation of powers of the Constitution. They have not gone the entire way of saying that it's the unitary executive, and for the unitary executive to be able to be fully realized, the president can have no limitations on his powers to fire somebody in a so-called independent agency. But that is very strongly the direction in which they are going. They have done it now with in cases in which they've distinguished this Humphreys executor case. They've said, well, this is a case in the CFPB example, Consumer Finance Protection Board. That's just a single person in charge. That's just too much power. That's just for one person to have that power and not be subject to the removal by the president for no reason. That's a violation of separation of powers. Sorry, we're striking that down. We're still leaving Humphrey's executor up. Oh, okay. Now here's another case that involves several body leading board, but they're doing all this sort of core kind of prosecutorial power. That's just the wrong kind of power to keep the president from being able to fire. So we're getting rid of that. And what has been left? Basically just the FTC itself, which is a multi-member board, and B, a board that doesn't exercise, straight up prosecutorial power of the executive. And it's been playing out in two different settings. Right now, the law is on the books. All of these have laws on the books where the Congress said, you can't just do it for no cause. You need to have a cause. And it's been that's been precisely under attack. And that Trump has said, you just cannot constrain me in that way. So it's been a matter of the court again and again saying, yeah, we think this is really goes too far, except it's all being done still on the shadow docket. It's all being done by lawsuits against the president for trying to do this And then the lower court saying, yep, this sure seems against the law to us. And then in a very kind of cryptic, often silent way, the Supreme Court say, no, this is okay, and we'll get back to you and explain why. But for now, we're not going to let you have this temporary relief. We have two lawsuits going on now. We talked about one involving Lisa Cook. Lisa Cook has been attempted to be fired by Trump because supposedly she committed mortgage fraud. It's the same kind of theory that they're bringing against other political enemies. Really, this is just about politics and trying to change the constitution of the FTC. But they're saying that she took out two mortgages called both primary residences. They've said the same against Adam Schiff, the same against Letitia James. Cook has come back strongly and said, I want a hearing here. This is not fair cause, and you still have to give me cause under the law as it exists. And the hearing seemed favorable for her because she was able to show, you already knew this about my mortgage fraud. You didn't call it a problem then. How can it be cause now? This is really just a pretext. All right, that's the Cook case, and it is separate. We have otherwise, though, a case against a different commissioner of the FTC, Rebecca Slaughter. She was fired without cause. It's clear that there was no cause here, and it's just a test case where Trump goes directly in the face of the congressional command saying you need some kind of cause, and he said, nope, you are out, and she sued. And the D.C. Circuit said, look, this is without cause, and it's a agency that focuses on consumer protection and antitrust issues. You've already said, we've said again and again, we're not getting rid of yet Humphrey's executor, so this should be, it's not to us to change. The dissenting judge, a Trump appointee, said, well, maybe. It's true that remains the law, but look at the way the court has dealt with the issue when it's come up on its emergency docket. They've made it pretty clear that Humphrey's executor holds on by a thread. Moreover, it's another step to force Trump to reinstate. Maybe you can try to say there's some remedy for it, but it shouldn't be forced for him to keep her. Now, all of this stuff, again, would have been revolutionary 5-6 years ago, but the court has one step at a time paved the way. So much so now that what happened most recently is Chief Justice Roberts, who is the circuit justice for the D.C. Circuit, where this order was given, just said, it is hereby ordered that we're staying it pending further order of the undersigned or of the court. You can file an application before me, but for now, at least, before we even think about what your argument is, Commissioner Slaughter, right now, the state of play is simply that the order below is stayed and she can be removed. Now, that would not be copacetic with the law as it currently exists. And so all of this is the kind of prediction game that plays out of late when they're talking about the shadow docket under the guise of who's likely to prevail in this case. I mean, the regime, as people understand it, is that you're supposed to apply the law as it stands, but when things go up to the Supreme Court, what Roberts is saying here is basically Humphrey's executor is toast, more or less. I mean, you can imagine he doesn't even go through all the kinds of factors. You can imagine a ruling that when it does come up this way, so now the ruling goes back to the DC Circuit for them to continue to do the merits, but with the stay having been removed. And they'll go through everything and might even say, we've got to apply the law as it is. But then when it comes to the Supreme Court, it would be a complete disconnect for him now to have said this, and then all of a sudden to said, but you know what, we're going to keep Humphrey's executor in. This is the second really tangible indication that Humphrey's executor is one for the chopping blocks. We had a first in another shadow docket case. They're doing everything shadow docket here with less than full explanations, making serious changes and inroads in constitutional law, basic separation of powers in very unsatisfactory ways. But they had said before in a case called Trump versus Wilcox, in a similar way, we predict that the United States is going to win its case, and therefore we're going to remove a stay. And here again, it's you've seen in other cases. Just yesterday, the petition sent to Justice Kagan, that was from the Ninth Circuit, and by her refer to the conference here. Roberts just did it on his own. He just said, I'm removing the stay. Go back and you do your business now. But just so you know, that sound you hear in the distance is the elegy for Humphrey's executor. And when this plays out, Ms. Slaughter, you are likely to have had the legal rug pulled out from under you, and to have found that notwithstanding the clear command in the FTC statute that is the actual guidelines for what the FTC is supposed to do and how its commissioners are supposed to be limited in their firing. Turns out that's not right. We're going to go with Trump once again on a theory of separation of powers that will leave next to nothing, maybe nothing left of the whole administrative state. And the sort of last kind of fighting battle will be the Fed and Powell, which the court has tried to distinguish, but which it seems very hard to sort of make a principled distinction for. And at that point, you might have complete sort of autocratic, arbitrary power on behalf of the president as against the entire alphabet soup of agencies, and be able to fire people willy-nilly, the whole regime based on some independence, some expertise, nonpartisanship will be utterly transformed. And the sort of success story of the New Deal and administrative state after will itself be under really huge challenge. Just one of the several humongous changes that the Supreme Court has acquiesced in under Trump 2.0. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.